know that most of what you've seen, read, or heard about Billy the Kid is untrue? My name is Gail Cooper. I'm a medical doctor and forensic psychiatrist. My specialty is murder case consultation for the defense. For 20 years, I've used my expertise to uncover the real Billy the Kid. Researching over 40,000 pages of archival documents and books, I've written the revisionist history. It's shocking, it's liberating, and I've written books demolishing the hoaxes, hijacking the history. My talks will share with you what I've found. Cover-ups, misinformation, and fakery, to use Old West lingo, will bite the dust. This talk presents my revisionist history of Billy Bonney's hanging trials in Mesilla. The information is from my book, The Lost Pardon of Billy the Kid, an analysis factoring in the Santa Fe Ring, Governor Lew Wallace's dilemma, and a territory in rebellion. Billy Bonney's Stinking Springs capture by Pat Garrett left him in the power of the Santa Fe Ring, now poised to kill him under guise of law by hanging. Governor Lew Wallace could have saved him by the promised pardon, but did not. Billy's indictments were for the regulator killings in the Lincoln County War of Sheriff William Brady, Deputy George Hinman, and posseman Andrew Buckshot Roberts. Loyal Ira Leonard was Billy's defense attorney in the first trial. Then, likely ring threat made him withdraw. So Billy was left with a ring-eyed judge, ring-eyed prosecutors, court-appointed prejudiced lawyers, press blaring outlaw myth propaganda, and an inevitable outcome. Attorney Ira Leonard had protectively accompanied Billy from his Santa Fe jail on the Atchison, Topeka, and Santa Fe Railroad, whose southward track construction had only reached the Rincon Depot before the ring got impatient to get Billy killed. Leonard stayed with Billy on the stagecoach to Las Cruces. With them were guards and fellow prisoner Billy Wilson. At Las Cruces, a crowd had gathered to see the famous outlaw, Billy the Kid. Someone asked which was Billy. As reported in the April 3, 1881 Santa Fe Daily New Mexican in Something About the Kid, Billy teasingly pointed to bald, middle-aged Leonard and declared, "This is the man." Billy also quipped, "At least 200 men have been killed in the Lincoln County during the past 3 years, but I did not kill all of them." Billy was brought to the Doña Ana County Jail, adjacent to the courthouse in Mesilla's Plaza. On March 30th, 1881, under ring-eyed Judge Warren Bristol, the first case to be tried was the regulator's April 4th, 1878 killing of John Tunstall murder posseman Andrew Buckshot Roberts. Santa Fe ring boss Thomas Benton Catron, as U.S. Attorney, had written its June 21st, 1878 federal indictment, case number 411, for Billy and other regulators. The ring thought it was airtight. Wallace couldn't pardon a federal case. It needed the president. The prosecutor was ring-eyed U.S. Attorney Sidney Barnes, Catron's replacement. But Attorney Ira Leonard surprised that court. He filed a motion to quash the indictment based on it being invalid. In the juryless hearing before Judge Bristol, with Prosecutor Barnes present, Leonard argued that Catron's indictment claimed federal jurisdiction by erroneously claiming that the Blazers Mill killing site was part of the federally controlled Mescalero Indian Reservation, Leonard stated that it was actually private property owned by a Dr. Joseph Blazer. Its being within the reservation's perimeter was irrelevant. As private property, it came under territorial law. Leonard was right. Judge Bristol was forced to withdraw the indictment. The ring had underestimated Ira Leonard. So the ring reverted to its usual response to serious opposition, death threat. Leonard, having barely survived a ring assassination on April 25, 1879, only 67 days after his office mate, attorney Houston Chapman's actual ring killing, abruptly departed. Billy was left with court-appointed attorneys for his William Brady and George Hinman murder trials. They were Albert Jennings Fountain, who believed the ring's outlaw myth, and Boss Catron's business and political associate, John D. Bale. To prejudice potential jurymen, Ring Press spewed the outlaw myth. On April 2, 1881, Newman's Semi-Weekly ran an article titled "The Kid." It stated, "The Kid is a notoriously dangerous character who has made his brags that he only wants to get free in order to kill 3 men, one of them being Governor Wallace. Should he break jail now, there is no doubt that he would immediately proceed to execute his threat. We hope that legal technicalities may not be permitted to render escape more probable." The legal technicalities was a swipe at Ira Leonard, meaning the ring would tolerate no courtroom truth to interfere with hanging. The next trial was the regulators' killing of Lincoln County's sheriff, case number 532, New Mexico Territory versus William Bonney, alias Kid, alias Henry Antrim, for the murder of William Brady. The prosecutor was Ringite District Attorney Simon Newcomb, one of the lawyers who'd freed by habeas corpus on April 13, 1879, Lew Wallace's captured Ringite Seven Rivers Rustler murderers being held in Fort Stanton. The transcript for that trial is lost, a likely ring expurgation. But under Ringite Judge Bristol, with complicit defense attorneys Fountain and Bale, with no defense witnesses, and with Ringite prosecution witnesses James Dolan, Jacob Basel, Billy Matthews, and Saturnina Baca, along with subpoenaed Lincoln merchant Isaac Ellis, Billy had no chance. Judge Bristol's prejudicial jury instructions do exist and show that he made first-degree murder the only possible verdict. Its only sentence was hanging. He told the jurymen, "There is no evidence before you showing that the killing of Brady is murder in any degree than the first. The punishment for murder in the first degree shall be death." Close quote. Since first-degree murder required premeditated design, Bristol made that inevitable also, stating, "If the design to kill is completely formed in the mind but for a moment before inflicting the fatal wounds, it would be premeditated and the same as though the design to kill had existed for a long time." He continued, "In this case, in order to justify you in finding this defendant guilty of murder in the first degree, you should be satisfied and believe from the evidence, to the exclusion of every reasonable doubt, of the truth of several propositions. First, that the defendant either inflicted one or more of the fatal wounds causing Brady's death, or that he was present at the time and place of the killing, and encouraged, incited, aided in, abetted, advised, or commanded such killing. Note that aiding and abetting are actually a lesser degree. In 1879, ring thug Jesse Evans got only accessory to murder in the Lincoln County grand jury for abetting the murder of attorney Houston Chapman. Second, that such killing was without justification or excuse. Note that Billy had no defense witnesses or motivated defense attorneys to argue for his justification or excuse. Third, that such killing of Brady was caused by inflicting upon his body a fatal gunshot wound. Note that Brady had 8 gunshot wounds indicating multiple shooters. And fourth, that such fatal wound was either inflicted by the defendant upon a premeditated design to effect Brady's death, or that he was present at the time and place of the killing of Brady, and from a premeditated design to effect his death, he encouraged, incited, aided, and abetted, advised, or commanded such killing. Note that this again lumps lesser offense of accessory with first-degree murdering. Bristol repeated his wrong instruction, stating, if he was so present, encouraging, inciting, aiding in, abetting, advising, or commanding the killing of Brady, he is as much guilty as though he fired the fatal shot. Note again, Jesse Evans' 1879 accessory to murder verdict for abetting Chapman's murder. And in Texas in 1880, Jesse and his gang had murdered a Texas Ranger. Jesse got second-degree murder by being present but not actually killing, the opposite to Bristol's instruction. Bristol continued, as to what would be or would not be reasonable doubt of guilt, I charge you that belief in the guilt of the defendant does not require mathematical certainty as 2 and 2 are 4, merely a vague conjecture or bare possibility that the defendant may be innocent is not sufficient to raise reasonable doubt of his guilt. Note that Bristol removed all options for reasonable doubt of guilt. Murder in the first degree is the greatest crime known to our laws. The punishment for murder in the first degree shall be death. If you believe, therefore, from the evidence before you, that the defendant is guilty of murder in the first degree, then it will be your duty, so saying in your verdict, that the defendant shall suffer the punishment of death. As discussed in Talk 11, linked below, Judge Warren Bristol's ringite judicial corruption had been exposed during 1870s anti-ring uprisings. In April of 1877, Colfax County war activist Mary McPherson sent charges against him and other Santa Fe ring officials to President Rutherford B. Hayes. She wrote that Bristol, quote, conspired together to corrupt and defraud justice and defeat the ends thereof with U.S. Attorney Thomas B. Catron, Chief Justice Henry Waldo, and Governor Samuel B. Axtell. She enclosed a copy of February 18, 1876's Grant County Herald's petition and charges to remove Judge Bristol. It stated, we charge that Judge Bristol is guilty of manifest partiality while acting in the trial of causes, close quote. That meant Bristol used his court to punish ring opponents. Noteworthy is that the petition cited his obstructing witnesses for the defense. In one case, he, quote, absolutely refused to the prisoner the right to procure witnesses in his behalf. It is known that Billy had no defense witnesses. There is no record of any being subpoenaed. Also existing are the prejudicial jury instructions by attorneys Albert Jennings Fountain and John D. Bale. It's known that Billy didn't testify on his own behalf. They may have discouraged him, though he was a master testifier, and they may have been to blame for not subpoenaing defense witnesses. Their paltry 312-word instructions were all that stood between Billy and Judge Bristol's noose. Yet they slyly backed Bristol's instruction that first-degree murder was the only charge possible by not informing the jurymen about lesser degrees of murder. They stated, "The court is asked to instruct the jury as follows, to wit, first instructions asked. Under the evidence, the jury must either find the defendant guilty of murder in the first degree or acquit him." Note that this repeats Bristol's wrong all-or-nothing instruction. Second instruction asked, "The jury will not be justified in finding the defendant guilty of murder in the first degree unless they are satisfied from the evidence, to the exclusion of all reasonable doubt, that the defendant actually fired the shot that caused the death of the deceased Brady, and that such shot was fired by the defendant with a premeditated design to effect the death of the deceased, or the defendant was present and actually assisted in firing the fatal shot or shots that caused the death of the deceased, and that he was present in a position to render such assistance and actually rendered assistance from a premeditated design to effect the death of the deceased." Note that Fountain and Bale are listing degrees of murder while calling them first-degree murder guilt. They list 1, firing the fatal shot, 2, firing it with premeditated intent to murder, 3, assisting in firing the shots, or 4, rendering assistance to murder. Note again that the assisting options were lesser degrees. As mentioned, in Chapman's murder, abetting got Jesse Evans indicted as an accessory, as opposed to Chapman's fatal shooters, James Dolan and Billy Campbell, who got first-degree murder indictments. Third instruction asked, "If the jury are satisfied from the evidence to the exclusion of all reasonable doubt that the defendant was present at the time of the firing of the shot or shots that caused the death of the deceased Brady, yet before they will be justified in finding the defendant guilty, they must be further satisfied from the evidence to the exclusion of all reasonable doubt that the defendant either fired the shots that killed the deceased, or that he assisted in firing said shot or shots, or assisted the parties who fired the same either by his advice, encouragement, procurement, or command from a premeditated design to effect the death of Brady. If the jury entertains any reasonable doubt upon any of these points, they must find a verdict of acquittal." Note that this repeats degrees of participation, but gives only acquittal as an option. This removed jurymen's choosing a lesser non-hanging degree of murder, since Billy's presence was never denied. But were there defense arguments that could have saved Billy? Would Ira Leonard have dared to use them? There's no doubt he opposed the ring. On May 20th, 1879, he'd written to Lew Wallace that the, quote, "Santa Fe ring has been so long an incubus on the government of this territory." And the real arguments required going head-to-head with the ring. So here are hypothetical arguments not used by Fountain and Bale, who I'll simply cite as Fountain. Though the trial's transcript is lost, one can extrapolate from the jury instructions of Fountain that no correct defense was offered Billy. Billy, however, was unaware of this betrayal and subsequently tried to sell his bay racing mare to pay Fountain for his appeal. Nevertheless, one can show that evidence and argument could have established reasonable doubt against first-degree murder verdict and its hanging penalty for the murder of William Brady. The argument should have been for justifiable homicide for defense of another, as forcing the group of men, which included the defendant, to use deadly force against Brady on April 1st, 1878, to stop his murdering Alexander McSween. If the group had responded to immediate threat, like seeing Brady attacking McSween, it would have been a complete defense for acquittal, comparable to self-defense. But the time gap of about 3 hours between Brady's killing and McSween's arrival in Lincoln for his future grand jury trial required a mitigating defense based on defendant William Bonney's certainty that Brady would kill McSween when McSween arrived. So trial evidence had to show why any reasonable person would think Brady was about to murder McSween. First, there was evidence for William Brady as a murderer, as follows. The posse under Brady had murdered McSween's friend, John Tunstall, just 42 days before Brady's own killing, and Brady had made a death threat to Tunstall in McSween's presence, stating, "I won't shoot you now, you haven't long to run." Brady, as a rogue lawman beholden to the ring, blocked arrest of Tunstall's killers, who were also Brady's deputies and posse men. And Brady illegally imprisoned the defendant on February 20, 1878, to obstruct his arrest of Tunstall's murderers in his capacity as a deputy constable appointed by Justice of the Peace John Wilson. Brady was a known threat to Alexander McSween, having maliciously harassed him by property attachment for his embezzlement case far in excess of the $8,000 set by Judge Bristol to satisfy a possible court judgment against him. Brady was a ring agent whose job was to kill McSween. McSween had gone into hiding because of certainty of Brady's murderous intent, and Las Vegas Deputy Sheriff Adolph Barrier had been so certain of McSween's murder risk from Brady that he had kept McSween in his personal custody. On March 28, 1878, Brady brought Fort Stanton soldiers to the ranch of John Chisholm in failed attempt to apprehend and likely kill McSween. And just 4 days after that, the murder day, Brady knew that McSween would return to Lincoln for his grand jury trial and could be murdered then. Importantly, there existed no legal way to stop Brady from murdering McSween, since by a March 9, 1878 illegal proclamation, then ring-eyed Governor S.B. Axtell had removed Justice of the Peace Wilson, stating, "There are no territorial officers here to enforce laws except Sheriff Brady and his deputies." Axtell himself was removed in late 1878 for that illegality. Therefore, seeing themselves as McSween's sole protection, citizens, including the defendant, came to Lincoln. They saw Brady and his deputies, all accused and indicted Tunstall murderers, heavily armed and positioning themselves for McSween's imminent arrival at the east end of town. Brady's murder intent was obvious. Secondly, there was evidence for defendant William Bonney's altruistic motive. As to defendant's character, he had been a ranch worker for murdered John Tunstall. He'd been deputized to serve warrants on Tunstall's murderers after Brady refused to do arresting, only losing his deputyship by its illegal removal by Governor Axtell. Defendant's commitment to law and order was further proved by his volunteering an eyewitness affidavit and a deposition about Tunstall's murder to bring Tunstall's assassins to justice. On the murder day, defendant was in a citizens group having sole consensus that McSween would be killed by Brady upon arrival. Furthermore, in that group, the defendant had only a revolver since Brady had confiscated his carbine and all others had carbines. Defendant lacked the range to Brady's position, so could not have been Brady's shooter. The defendant's intent was to save McSween's life, and killing Brady was the only possible way to achieve that end. There were other trial variables open to censure. No translator was provided to the Spanish-speaking jury except for jury instructions, even though a translator was required. Defense witnesses should have included Billy himself and subpoenaed Deputy Adolph Barrier, John Squire Wilson, and Juan Patron. Prosecution witnesses James Dolan and Jacob Basil Matthews should have been impeached as being on Brady's murder posse and themselves indicted for Tunstall's murder. Here is a hypothetical defense argument for a fair court. Self-defense murder is legally blameless. So is defense of another from immediate death. The weight of the evidence has shown that defendant William Bonney shared with his companion's certainty that William Brady was about to kill attorney Alexander McSween and that no recourse existed except to kill Brady to save McSween. Defendant had no motive to kill Brady except in defense of McSween. To protect another from certain death is noble and mitigates against a verdict of first-degree murder, which is wanton and with malice aforethought. The evidence has shown that after Brady's posse murdered John Tunstall, there was good reason for the defendant to believe Brady would next kill Alexander McSween. It has been shown that McSween himself and Deputy Sheriff Barrier likewise believed that Brady would kill McSween. It has been shown that no legal recourse through public officials existed to stop Brady's murderous act. Furthermore, the defendant was not Brady's killer, since his revolver lacked range and his companions had carbines which could attain the range to strike Brady. And the defendant was not wanton or malicious, since his intent was to preserve McSween's life. All the evidence therefore mitigates against a verdict of first-degree murder, which requires hanging, and should be morally repugnant to declare against a reasonable man acting to save the life of another man. It is the burden of the territory, not the defendant, to prove beyond reasonable doubt that the defendant did not act in defense of another. The prosecution, having used Brady's indicted fellow murderers as witnesses, has failed to do that. So if you, the jurors, have reasonable doubt that the defendant acted in defense of another, you cannot find him guilty of first-degree murder and are free to find him not guilty or at most guilty of a lesser degree of murder which spare his life. On April 9, 1881, in Billy Bonney's real and corrupt trial for William Brady's killing, the jury's inevitable verdict after Bristol's and Found's instructions, was murder in the first degree. On April 13, 1881, Bristol sentenced Billy to hang a month later, on May 13th, leaving little time to appeal. It should be noted that if the Brady and Hinman indictments did not yield a hanging sentence, Bristol could have gotten a territorial one against Billy for the Roberts killing. Billy responded to the injustice in an interview published in the April 16th Messiah News. In summary, he stated, "I think it hard that I should be the only one to suffer the extreme penalty of the law." He called his court mob law, ending with facetious personal advice. If mob law is going to rule, better dismiss judge and sheriff and let all take chances alike. He added Lew Wallace's pardon bargain betrayal by saying curtly, "Don't know that he will do it." The article stated, "Well, I had it intended at one time not to say a word on my own behalf, because persons would say, 'Oh, he lied.' Newman, editor of the Semi-Weekly, gave me a rough deal. He created prejudice against me and is trying to incite a mob to lynch me. He sent me a paper which showed it. I think it a dirty, mean advantage to take of me, considering my situation and knowing that I could not defend myself by word or act. But I suppose he thought he would give me a kick downhill. If mob law is going to rule, better dismiss judge and sheriff and let all take chances alike. I expect to be lynched going to Lincoln. Advise persons never to engage in killing. Considering the active part Governor Wallace took on our side and the friendly relations that existed between him and me, and the promise he made me, I think he ought to pardon me. Don't know that he will do it. I think it hard that I should be the only one to suffer the extreme penalty of the law." In darkness, on April 17, 1881, Billy was secretly transported by wagon from the Messiah jail to prevent rescue attempts. Newman's Semi-Weekly reported his departure, with Billy as usual joking. It stated, "On Saturday night about 10 o'clock, Deputy U.S. Marshal Robert Ollinger, with Deputy Sheriff David Woods and a posse of 5 men, started for Lincoln with Henry Antrim, alias the Kid. The fact that they intended to leave at that time had been purposely concealed, and the report circulated that they would not leave before the middle of the week, in order to avoid any possibility of trouble, it having been rumored that the Kid's band would attempt a rescue. They stopped in front of the Semi-Weekly office while we talked to them, and we handed the Kid an addressed envelope with some paper, and he said he would write some things he wanted to make public. He appeared quite cheerful and remarked that he wanted to stay until their whiskey gave out anyway. Said he was sure that his guard would not hurt him unless a rescue should be attempted, and he was certain that it would not be done unless perhaps those fellows at White Oaks come out to take me, meaning to kill him. It was, he said, about a standoff, whether he was hanged or killed in the wagon. Having sacrificed Billy Bonney to save himself, Lew Wallace faced a golden future. On April 19, 1881, he got a letter from a new father figure, President James Garfield, praising his new book, Ben-Hur, A Tale of the Christ, and even being kind about the Battle of Shiloh. It led to Wallace's appointment to his coveted ambassadorship to Turkey. Garfield wrote, "Dear General, I have this morning finished reading Ben-Hur. I must thank you for the pleasure it has given me. With this beautiful and reverent book, you have lightened the burden of my daily life and renewed our acquaintance, which began at Shiloh. Very truly yours, J.A. Garfield." A later talk will cover Billy's attempted appeal of his hanging sentence.